It's not often I can speak assuredly without someone accusing me of defamation. These days, even when you're reporting facts, if someone doesn't like what you say, they'll label it slander. That's essentially what Meta argued in response to Stephanie Jones' motion to compel user information connected to this Stephanie Jones Lies Facebook page. They insisted she must show that the content was defamatory, yet it wasn't. It falls under First Amendment protected speech. Now, there are individuals with a reputation for consistently spreading falsehoods while driving public narratives. Blake Lively and Ryan Reynolds fall squarely into that category. This very narrative played out in court just yesterday. Remember when I said the era of intimidation was coming to a close? That statement still stands. Some people accused my prior video of being misleading clickbait. But from my perspective, and I think most creators involved in this story would agree, there has been a constant looming threat. Personally, I've received cease and desist letters. Others have been issued subpoenas or publicly defamed. One example is Shasty, who was ridiculed but never even subpoenaed. However, once the judge stated that all subpoenaed documentation must be turned in by July 25th, it signaled a shift. It means no more subpoenas can be issued, which is a relief for independent creators like myself who are at risk of getting pulled into the legal mess. If Perez hasn't yet received a subpoena, he likely won't be involved at all. And if records must be turned over within 2 weeks, people like Candace and Andy could also be out of the crosshairs. This is all extremely positive. It signifies that Blake and her team can no longer use the legal system to target independent voices. When they requested permission to submit their motion, Blake Lively's legal team launched an exaggerated accusation at Brian Freriedman and attached with it a massive 300-page document. This document was prepared by an attorney who represents a former assistant who briefly worked just 9 days for Vin Diesel in 2010. That assistant is now suing Diesel under a newly enacted law championed by Gavin Newsom, which extended the statute of limitations for victims of sexual assault, dating back to 2009. If someone had a legitimate claim from 2009 or earlier, they could now pursue legal action as an employee. However, this didn't change the obligations under the CRD, California Civil Rights Department. The assistant filed a lawsuit alleging things like negligence and workplace discrimination, but all employment-related claims were dismissed due to the time limits. She didn't file with the CRD in time. What remains in the case are just the SA and personal claims. Vin Diesel has denied all allegations.